Now, let's talk about the termination, the due diligence provision and termination under the due diligence provision, and that due diligence fee and the earnest money. Now, the due diligence is under paragraph 8. Okay, that is a different paragraph than the earnest money. The earnest money paragraph did not change in any way. None of the requirements for earnest money, none of the requirements for deposit of earnest money, return of earnest money should the contract not go forward, none of that. All of that's in paragraph 5. It's not in paragraph 8. So the change in paragraph 8 does not affect earnest money. Okay, 5 does not equal 8. That's pretty basic, but that's a good way to remember it. Okay, same conditions for disbursement of the earnest money exist. If the contract is terminated, there would still need to be a release signed for the earnest money to be returned. The escrow agent is going to require, there are 4 ways in the contract. It says under all circumstances, there are 4 ways, either voluntary, a signed agreement, which could either be voluntarily they agree and sign it, or through after mediation. The interpleader action, if the earnest money is $7,500 or less, the interpleader action can be filed in small claims court. If it's over $7,500, it can't be. So that may be a consideration when you're determining how much your earnest money is. Do you want it to be over $7,500? And if there's a problem, have to go what I call big boy court or circuit court, or keep it at $7,500 or less so there can be an interpleader action. Excuse me. Of course, the other ways in the contract, I said court, I said interpleader, voluntary mediation, or an agreement, or you can do mediation to help come to an agreement. But those are the ways that earnest money is to be dispersed, and nothing changes. There is no automatic right to the earnest money just because there would be some type of proper termination under paragraph 8. That does not change whether or not the how the earnest money is handled. Okay, so same way, we've got a signed release, either the 517 that releases earnest money, or 518 that is a release from the contract and the earnest money, mediation, or we have the courts, the orders of the court. Nothing, absolutely nothing changes. So same deposit rules. If the broker is holding the earnest money, then of course that earnest money must be given to the broker by the next business day. And then the same deposit rules for the broker, with 48 hours for cash, certified check, 48 hours after it's received, delivered on the next business day, deposited within 48 hours, or 48 hours after the contract is accepted if it's a personal check. Okay, so they would need to be separate checks. We're not going to have one check for the termination fee and the earnest money. There has been some talk of the due diligence fee being taken from the earnest money. That is certainly, I don't think there's necessarily good practice, not a law prohibiting that. But of course, that predisposes that the termination fee is less than the earnest money. Probably not a good practice to go there. And the other thing that has been determined was possibly considered having the earnest money deposited after the due diligence period is run. That way, if the problem we have, though, of course, if I've missed the termination, there's no real incentive for me. If I'm not going to pay a termination fee, there's no real incentive for me to deposit the earnest money. And you say, well, you wouldn't have to if you've terminated. Well, if there's some other breach of the contract, I'm not exactly coming up with what it is now. I'm just saying that earnest money is usually considered to be something on deposit more in line if there's a breach of the contract, and not just a separate. But that would certainly need to be something that's addressed by the parties and the particular brokerage. Each of your broker charges will do that. Now, there would need to be a signed release, and the best time to do that, of course, I would think would be at the time that the termination fee is delivered, or could be done with the form 313 notification, notice of termination. They should be done together, but it does require that there be something signed. So that would be the perfect time to do it rather than waiting later. Okay, so to a really simple, nothing's changed at all here. Just remember the check should be separate from the earnest money check, and the timing of when it's paid is certainly a consideration depending on due diligence and what people are doing.